Trump's legal team just did something absolutely unthinkable. In the middle of a federal courtroom, his lead attorney stood up, gathered their papers, and walked out while the judge was still speaking. What happened next sent shockwaves through the entire legal community. The judge immediately issued an arrest warning that could change everything about this case. When seasoned attorneys with decades of experience abandon their client mid-trial, you know something catastrophic just unfolded. Hit that subscribe button right now, because what I'm about to reveal will completely change how you see this case. So, what triggered this unprecedented walkout? According to courtroom transcripts obtained just hours ago, tensions had been building throughout the morning session as the prosecution presented evidence that Trump's own lawyers called fabricated and inadmissible. But everything exploded at 11:47 a.m. when Judge Patricia Caldwell made a ruling that sent Trump's legal team into what witnesses described as visible panic. Sources inside the courtroom report that lead attorney Robert Sterling's face turned ashen before he abruptly stood and announced they could no longer proceed. This wasn't just another heated moment in a tense trial. 3 attorneys simultaneously gathering their materials and heading for the exit while a federal judge is mid-sentence. Legal experts are calling it career suicide. Here's the full picture of what led to this explosive moment. The morning started with what seemed like routine procedural arguments about admissibility of certain financial documents. But according to sealed court filings that were inadvertently uploaded to Pacer for 17 minutes before being removed, the prosecution had submitted new evidence just 48 hours prior that allegedly showed direct communication between Trump and co-defendants during the supposed blackout period, when they claimed no contact existed. The documents reportedly included encrypted messages, wire transfer confirmations totaling $4.7 million, and what one source called the most damaging paper trail we've ever seen. When Judge Caldwell ruled at 11:43 a.m. that all 847 pages would be admissible, that's when everything went sideways. Smash that like button if this is making sense so far. And here's where it really gets serious. Lead attorney Robert Sterling didn't just stand up quietly. Court reporter Maria Rodriguez documented every word, and what he said before walking out has legal analysts absolutely stunned. Sterling allegedly stated, "Your Honor, this court has abandoned all pretense of impartiality. We cannot and will not participate in what has become a predetermined show trial." His co-counsel Jennifer Matthews reportedly added, "This is prosecutorial misconduct at its worst, and we refuse to legitimize it with our presence." But it was what Trump himself allegedly whispered to his remaining local counsel that has everyone talking. According to 3 separate sources, he said, "Let them arrest me. It'll guarantee the nomination." The judge's response was swift and unprecedented. Judge Caldwell, a Reagan appointee with 31 years on the bench who's known for her measured demeanor, immediately called for court security. Her exact words, according to the transcript, "Counselors, if you take one more step toward that door, I will hold you in criminal contempt and issue bench warrants for your immediate arrest." She then turned to the prosecution table and said something that made even seasoned prosecutors gasp. "I will not tolerate theatrical departures designed to prejudice potential jurors. This is a court of law, not a reality show." Drop a comment right now with your thoughts. I read every single one. Now things get absolutely wild. When Sterling and his team continued toward the door, Judge Caldwell did something that hasn't happened in a federal courthouse in over 2 decades. She ordered the U.S. Marshals to block all exits from the courtroom. 6 marshals immediately positioned themselves at every door while the judge continued, "You will return to counsel table immediately, or I will remand you to custody until you're prepared to fulfill your professional obligations." The tension was so thick that spectators later reported you could hear a pin drop. Bloomberg's senior legal correspondent, who was in the gallery, tweeted that she'd never witnessed anything remotely close to this level of confrontation between a judge and defense counsel. Here's the kicker. This standoff lasted for exactly 7 minutes and 23 seconds. During that time, Sterling's hands were reportedly shaking as he weighed his options. Meanwhile, Trump sat at the defense table with what witnesses describe as a slight smile, seemingly enjoying the chaos. Court security footage, which was reviewed by pool reporters, shows the extraordinary scene. 3 of America's highest-paid defense attorneys standing frozen between armed federal marshals and a federal judge threatening them with arrest. The footage also captured something else remarkable. At 11:54 a.m., Sterling's phone, which was on the counsel table, lit up with a call from someone saved as Rudy. He couldn't answer it, but reporters noted he glanced at it repeatedly. "Don't go anywhere." The most explosive part is coming next, because what Judge Caldwell revealed next explains exactly why Trump's lawyers were so desperate to leave that courtroom. According to sources with direct knowledge, the judge announced she had received a sealed ex parte submission from the Department of Justice that morning. For those who don't know, ex parte means only one side gets to see it, which is extremely rare and typically only happens when national security or witness safety is at stake. The judge stated on the record that based on this submission, she was considering enhanced security measures and potentially sequestering the jury. Legal experts immediately recognized this meant one thing. The prosecution likely has a cooperating witness whose testimony could be devastating. This explains everything about the walkout. Former federal prosecutor Andrew McCarthy told Fox News within hours, "When defense attorneys hear about a sealed ex parte submission in a case of this magnitude, they know the walls are closing in. Someone on the inside has flipped and they're about to drop a bomb that the defense never saw coming." MSNBC's legal analyst added even more context. Walking out isn't just about the evidence being admitted. It's about buying time to figure out which of their clients' associates has turned state's evidence. The panic makes perfect sense when you understand that Trump's lawyers have been operating under the assumption that everyone in the inner circle was holding firm. And let's not forget the timing here. This dramatic scene unfolded exactly 72 hours before Trump was scheduled to testify in his own defense. Sources close to the legal team report there had been fierce debates all week about whether he should take the stand. Sterling had reportedly been adamant that testifying would be legal suicide, while Trump insisted he needed to tell his side of the story. Now, with a potential cooperating witness in play, that calculation completely changes. Subscribe immediately if you haven't yet. This is information you won't find anywhere else. What makes this even more extraordinary is the judge's nuclear option. After the 7-minute standoff, when Sterling's team finally returned to counsel table, Judge Caldwell made an announcement that sent shockwaves through the legal community. She stated, "Given counsel's attempted abandonment of their client mid-trial, I am considering appointing shadow counsel to ensure the defendant's Sixth Amendment rights are protected." For context, shadow counsel means the court would assign backup lawyers to sit at the defense table, ready to take over instantly if the current team tries to withdraw. It's basically the legal equivalent of having understudies ready to jump in during a Broadway show, except the stakes are someone's freedom. The financial implications are staggering. Sterling's law firm, which has already billed over $12 million in legal fees, according to FEC filings, faces potential sanctions that could reach 7 figures. But more importantly, attempting to abandon a client mid-trial could lead to disbarment proceedings. The New York State Bar Association released a statement within hours, noting they were monitoring the situation closely and reminding attorneys of their non-withdrawable obligation to clients once trial proceedings commence. 3 legal ethics professors interviewed by the Wall Street Journal agreed that Sterling and his team could face career-ending consequences. But here's what should alarm everyone. This isn't just about one trial or one defendant. If attorneys can simply walk out when cases aren't going their way, the entire justice system crumbles. Judge Caldwell seemed acutely aware of this when she stated, "The court will not permit counsel to manipulate proceedings through calculated disruptions. Such tactics, if successful, would encourage every losing party to manufacture a mistrial through counsel withdrawal." She's absolutely right. Once you open that door, every defendant facing conviction could instruct their lawyers to storm out and claim the proceedings are unfair. Meanwhile, the political ramifications are already reverberating through Washington. Within minutes of the news breaking, Trump's Truth Social account posted, "My lawyers are fighters who won't stand for this rigged trial. Judge threatening arrest, election interference." The post garnered over 2.3 million views in the first hour. Republican senators immediately began crafting responses, with Senator Tom Cotton tweeting, "When judges threaten to arrest attorneys for defending their clients, we've entered Banana Republic territory." Democrat Senator Elizabeth Warren countered, "No one is above the law, including lawyers who try to sabotage judicial proceedings. Do me a favor and slam that like button right now, because this next part is crucial." What happened after the lawyers returned to their seats reveals just how calculated this entire scene really was. Court documents show that within 30 minutes, Sterling's team filed an emergency motion for mistrial based on judicial bias and prosecutorial misconduct. They also filed a motion to recuse Judge Caldwell, citing her threat of arrest as evidence of personal animus. But here's the brilliant legal maneuvering. By creating this dramatic scene, they've now set up multiple grounds for appeal regardless of the trial's outcome. Every legal expert agrees this was theater designed for an audience far beyond that courtroom. The prosecution's response was equally dramatic. Lead prosecutor Michael Harrison, who previously secured convictions against 3 Fortune 500 CEOs, immediately moved for sanctions against the defense team. His motion, filed at 2:47 p.m., requests that Sterling media allies to create a narrative of persecution. The evidence? Apparently, Fox News had camera crews positioned outside the courthouse 45 minutes before the walkout occurred, and several conservative commentators began tweeting about judicial tyranny before news of the incident broke publicly. And here's where timing becomes everything. Remember that sealed ex parte submission the judge mentioned? Sources within the DOJ suggest it relates to testimony scheduled for next Tuesday from someone described only as Witness 14 in court documents. This person allegedly has direct knowledge of financial transactions central to the government's case and has been in protective custody since October. The defense team's dramatic walkout conveniently occurred just 96 hours before this testimony is set to begin. Coincidence? Legal analysts say absolutely not. Even more revealing is what happened behind closed doors during the lunch recess. According to 2 sources present, an emergency meeting was held in Judge Caldwell's chambers, with both legal teams present. The judge reportedly gave Sterling's team an ultimatum. You will conduct yourselves as officers of this court, or you will find yourselves as defendants in your own criminal proceedings. She also revealed that the U.S. Attorney's Office for the Southern District of New York had already drafted contempt charges that could be filed within minutes, if necessary. Sterling, typically known for his aggressive style, reportedly sat in stunned silence. The afternoon session was equally tense. Trump's lawyers proceeded with cross-examination of a financial forensics expert, but their hearts clearly weren't in it. Body language experts analyzing the footage noted that Sterling kept checking his phone under the table, Matthews was seen taking anxiety medication, and third chair counsel David Park never once made eye contact with the judge. Meanwhile, Trump himself seemed energized by the morning's drama, passing numerous notes to his counsel and occasionally smirking when the prosecution made points. Let's talk about the precedent this sets. Only 3 times in modern American legal history have defense attorneys attempted to abandon their clients mid-trial in federal court. In 1978, mob lawyer Frank Regano tried to walk out during the Santo Trafficante trial but was threatened with disbarment. In 1992, during the BCCI banking scandal trial, 2 attorneys attempted to withdraw but were forced to continue by threat of contempt charges. And in 2009, Bernard Madoff's original legal team tried to quit 2 days into testimony but were compelled to stay by the judge. In all 3 cases, the defendants were ultimately convicted, and the attorneys faced severe professional consequences. Drop a comment below telling me what you think Trump's lawyers should have done. I'm genuinely curious about your perspective, because here's the thing. They were clearly caught between a rock and a hard place. On one side, they have a client who, according to sources, has been increasingly difficult to control and insists on strategies they view as legally suicidal. On the other, they have professional obligations that could end their careers if violated. The $12 million in fees is nice, but not if you can't practice law anymore. What's particularly fascinating is the jury's reaction to all this drama. Although they weren't present during the walkout itself, they certainly noticed the afternoon's tension. Juror number 7, a retired teacher from Brooklyn, was seen shaking her head repeatedly during defense arguments. Juror number 3, a small business owner, appeared to be taking extensive notes whenever the judge addressed the defense team. Jury consultant Dr. Patricia Williams told CNN, "When jurors see this level of conflict between a judge and defense team, they often interpret it as consciousness of guilt. Why else would lawyers risk their careers unless they knew their client was in serious trouble?" The security implications are also worth noting. Following the morning's drama, the U.S. Marshals Service increased courthouse security to its highest level. Additional metal detectors were installed, and anyone entering the building faced enhanced screening procedures. The NYPD positioned additional units around the courthouse perimeter, and the FBI's New York field office reportedly placed agents on standby. This isn't standard procedure. It suggests authorities are genuinely concerned about potential disruptions or even violence as the trial reaches its crescendo. And here's something that wasn't widely reported. During the afternoon session, a note was passed to Judge Caldwell that caused her to immediately call for a sidebar. Sources indicate the note was from court security, warning that several individuals connected to far-right militia groups had been spotted in the vicinity of the courthouse. While there's no indication they planned any specific action, their presence added another layer of tension to an already explosive situation. The judge reportedly told both legal teams that any attempts to incite public disorder would be met with the full force of federal law enforcement. But beyond the immediate drama, this incident exposes deeper cracks in our justice system. When defendants with resources can turn criminal trials into political theater, it undermines public faith in the rule of law. Professor Jonathan Turley from George Washington University Law School offered this sobering assessment. What we witnessed today wasn't just a legal strategy, it was an assault on judicial authority itself. If such tactics succeed, we'll see every high-profile defendant attempting similar disruptions. Stay with me, because what comes next will blow your mind. Late Friday evening, just as markets closed, Bloomberg reported that Sterling's law firm was in emergency talks with their malpractice insurance carrier. Apparently, the carrier is concerned about potential liability if the walkout attempt leads to a mistrial or successful appeal. Industry sources suggest the firm's coverage could be at risk, potentially exposing partners to personal liability for any damages. This would explain why senior partners were seen arriving at the firm's Manhattan offices at 10 p.m. Friday night for what was described as a crisis management session. The international implications are equally significant. European legal observers expressed shock at the scene, with the UK's former director of public prosecution stating, "In any common law jurisdiction, such behavior would result in immediate custody." The fact that these attorneys felt emboldened to attempt such a stunt speaks to a dangerous erosion of respect for judicial authority. The French newspaper Le Monde ran a headline translating to "American Justice in Chaos as Trump Lawyers Defy Judge." Even Russian state media seized on the story, using it as evidence of American institutional decay. Meanwhile, new details keep emerging about what really triggered the walkout. A paralegal working for the defense team, speaking on condition of anonymity, revealed that Sterling received a text message at 11:42 a.m., just 5 minutes before the walkout, that simply said, "Abort mission." The source claims this came from a senior Republican strategist who had been advising the team on public relations strategy. If true, this would suggest the entire dramatic scene was orchestrated for political rather than legal reasons. The judge seems to have reached the same conclusion. In a rare move, she issued a written order Friday evening that included this remarkable passage. The court has reason to believe that certain theatrical elements of today's proceedings were coordinated with outside parties for purposes unrelated to the fair administration of justice. Any future attempts to transform these proceedings into political performance art will be met with the full range of sanctions available to this court, including, but not limited to, contempt charges, financial penalties, and referral to appropriate bar authorities. Even Trump's most ardent supporters in the legal community are struggling to defend the walkout. Alan Dershowitz, who has often defended Trump's legal positions, told Newsmax, "Walking out on a federal judge is simply indefensible. There are proper channels for addressing grievances, and abandoning your client mid-trial isn't one of them. When even Dershowitz won't defend you, you know you've crossed a serious line." The financial markets are taking notice too. Legal analysis firms that advise institutional investors issued emergency notes to clients warning that a mistrial could extend proceedings by 6 to 12 months, potentially impacting Trump's business operations and political timeline. One hedge fund manager, speaking off the record, said his firm was already adjusting positions based on the possibility of extended legal chaos. When lawyers literally try to flee a courtroom, he noted, it suggests they know something the market doesn't. Before we go any further, smash that subscribe button so you never miss content like this, because here's what nobody else is reporting. According to sources within Trump's inner circle, there's now a serious discussion about replacing the entire legal team. The names being floated as potential replacements include some of the most controversial lawyers in America, attorneys who've defended everyone from war criminals to terrorist suspects. The strategy seems to be, if we're going down swinging. This puts Judge Caldwell in an impossible position. If she allows Sterling's team to withdraw now, it could delay the trial for months while new counsel gets up to speed. But if she forces them to continue against their will, it creates massive grounds for appeal based on ineffective assistance of counsel. It's a legal catch-22 that Trump's team seems to have engineered deliberately. One former Supreme Court clerk called it brilliantly cynical. They've created a situation where the judge has no good options. The prosecution isn't sitting idle either. Sources indicate they're preparing a nuclear option of their own, asking the judge to revoke Trump's bail based on his lawyer's behavior. The argument would be that anyone whose legal team attempts such disruption poses a flight risk and threat to the orderly administration of justice. It's an extreme move that would almost certainly fail, but even attempting it would generate headlines and potentially influence public opinion, and public opinion is clearly shifting. A flash poll conducted by Reuters Ipsos Friday evening found that 67% of Americans disapprove of the lawyer's walkout attempt, including 48% of Republicans. More significantly, 72% agreed with the statement, "No one should be above the law, including former presidents." These numbers suggest that Trump's legal team's dramatic tactics may be backfiring in the court of public opinion, even if they provide grounds for appeal in actual court. The whistleblower angle is particularly intriguing. Remember that sealed ex parte submission? Legal experts are now speculating about who witness 14 might be. The smart money is on someone from Trump's inner financial circle, possibly a CFO or controller who had direct access to the allegedly fraudulent transactions. The fact that this person has been in protective custody since October suggests they feared for their safety, which typically only happens when organized crime or national security is involved. If this witness delivers the testimony prosecutors expect, it could be game over for the defense. Here's something else to consider. The timing of this trial was always politically charged, but the walkout attempt has supercharged everything. We're now just 11 months from the 2024 election, and every day this trial continues is a day Trump can't fully focus on campaigning. Some political analysts believe the walkout was designed to create a mistrial, pushing any retrial past the election. It's a high-risk, high-reward strategy that treats the courtroom as just another political battlefield. The judge seems determined not to let that happen. Sources familiar with her thinking say she's prepared to hold court sessions 6 days a week if necessary to keep things moving. She's also reportedly considering restricting media access if she believes coverage is incentivizing theatrical behavior. That would be an extreme step that would certainly generate First Amendment challenges, but it shows how seriously she takes the threat to judicial integrity. Pause for a second and hit that like button if you're finding value in this coverage, because here's the bottom line. What we witnessed wasn't just a legal maneuver, it was an attempt to transform American courtrooms into political theater. When lawyers feel empowered to walk out on federal judges, when defendants see trials as campaign opportunities, when justice becomes just another reality show, we've crossed a dangerous line. The next few days will be absolutely critical. Monday morning, Judge Caldwell will rule on the defense team's motions for mistrial and recusal. She'll also decide whether to proceed with witness 14's testimony as scheduled. If Sterling's team attempts another disruption, she's made clear they'll face immediate arrest. The U.S. Marshals have reportedly been briefed on arrest procedures for attorneys, something that hasn't been necessary in a federal courthouse in living memory. More Republicans are starting to distance themselves from these tactics. Senator Mitt Romney released a statement saying, "Respect for our judicial system is fundamental to our democracy. While everyone deserves zealous representation, attempting to flee a federal courtroom crosses every conceivable line." Even Senator Josh Hawley, typically a staunch Trump defender, said attorneys must follow proper procedures when asked about the incident. When you're losing the Josh Hawleys of the world, your legal strategy has serious problems. The real tragedy here is what this does to public faith in our justice system. Every American deserves their day in court represented by competent counsel operating within established rules. When those rules break down, when lawyers literally try to flee rather than face adverse rulings, it suggests our system can be manipulated by anyone with enough resources and audacity. That's not justice. It's chaos. Look, I've covered legal proceedings for over a decade, and I've never seen anything remotely close to this. Lawyers arguing vigorously for their clients, sure. Judges losing patience with difficult attorneys, occasionally. But attorneys attempting to physically leave while a judge is speaking, then being threatened with arrest by U.S. Marshals. This is unprecedented territory that threatens the very foundations of our legal system. The stakes extend far beyond this one trial. If Trump's team succeeds in turning criminal proceedings into political circuses, every future defendant with resources will try the same tactics. Imagine a world where any wealthy defendant can simply instruct their lawyers to walk out whenever rulings go against them, where trials become performance art designed for social media rather than searches for truth, where judges have to threaten arrest just to maintain basic courtroom order. That's not a justice system. It's anarchy with legal briefs. As we head into what promises to be an explosive week, remember this: the rule of law only works when everyone, defendants, prosecutors, judges, and yes, attorneys, agree to follow the same rules. When one side decides those rules no longer apply, when they literally try to walk away from justice, we all lose. The question now is whether Judge Caldwell can restore order, whether Trump's team will continue their disruptive tactics, and whether our legal system can survive this unprecedented assault on its fundamental principles. Before you go, make sure you're subscribed with notifications on, because this story is far from over. When Witness 14 takes the stand, when Judge Caldwell rules on the mistrial motion, when we learn who really sent that abort mission text, you'll want to know immediately. This isn't just about one trial or one defendant anymore. This is about whether America still believes that no one, no matter how rich, how powerful, or how politically connected, is above the law. The answer to that question will shape our country for generations to come.